welcome to today's webinar on witnessing affidavits. My name is Belinda and I'm here with you today from the Justices of the Peace Branch. Today's webinar is all about affidavits. What are affidavits? Why would someone make an affidavit? What's the difference between sworn and affirmed? And how do you witness an affidavit? It's these questions and hopefully some more that I should be able to answer for you today. Let's begin. What is an affidavit? The Acts Interpretation Act 1954 defines an affidavit in relation to a person allowed by law to affirm, declare or promise. In essence, an affidavit is a written statement that sets out facts, that is, a person's story. Prepared by a party or witness known as the deponent, affidavits are primarily used to provide evidence in a court of law. The form of an affidavit may vary according to the type of oath or affirmation used and the court laws presiding. When the deponent makes an affidavit, it must be sworn or affirmed, and I'll explain what this means a little later on. But if you are presented with an affidavit that is not being submitted to a court of law, this should not be a reason to decline to witness the document. That is, the receiving agency that is requesting the affidavit, they may have governing legislation or their own requirements that allows this person to prepare an affidavit for that agency. And who may witness or who may take affidavits? The Act that authorises a person to take affidavits is the Queensland Oaths Act 1867. There are, however, a number of other acts and court rules that govern the requirements of an affidavit. That is, the format of an affidavit and how it must be submitted to a court of law. You'll see here under section 41 of the Oaths Act 1867, a commissioner for declarations are authorised witnesses. You are also allowed to take an affidavit for Queensland law in or outside of Queensland, including outside of Australia. So what that means is you may witness an affidavit anywhere in the world. I'm going to give you a few moments just to read this section of the Act to familiarise yourself with the Oaths Act 1867. As mentioned, the Oaths Act 1867 is the overarching act that allows a person to take an affidavit. However, while it is your role, to take the oath or affirmation and witness a deponent's signature on an affidavit, there are a number of Queensland and Commonwealth Acts that govern how the evidence, that is the affidavit, and any attachments must be submitted to the court. So I'll give you a little bit of background about the court process. The types of matters that a court or tribunal can deal with are known as jurisdictions. In effect, the jurisdiction of a court or tribunal has the power or authority to hear cases and make decisions in all of the areas that the court can deal with. Usually the jurisdiction of the court or tribunal is set down in an act authorised by Parliament. So an example of this is currently being displayed, and one of the most commonly witnessed affidavits is actually made under the Uniform Civil Procedure Rules, or the UCPR. These rules provide procedural framework for matters that are before the Magistrates, District or Supreme Court in Queensland. And if these rules aren't adhered to, then the court may not accept the affidavit, regardless if it had been witnessed correctly. Now, it is important to be aware of these procedural processes or these court rules, but I would like to highlight with you that it is not your role to be aware of the actual court rules that govern how an affidavit is to be submitted. That is why the deponent needs to seek their own independent advice to ensure that these court rules are being governed or are being adhered to. So continuing to the example on your screen, you've got the Authorising Act of the Supreme Court of Queensland Act 1991, and in that Act lives the Uniform Civil Procedure Rules 1999, and then you'll see here section 431 of those rules actually lists a number of requirements for how an affidavit must be submitted to that court. Some other common affidavits that you may witness, which are also governed by an Authorising Act and court rules, is the Magistrates Court Act 1921 and the Domestic and Family Violence Protection Rules 2014. So that would mean if anyone was submitting an affidavit in relation to a domestic and family violence matter in the Magistrates Court, they would have to ensure that these rules are adhered to when they are formatting or submitting an affidavit. Another common affidavit or act is the Queensland Civil and Administrative Tribunal Act 2009. And in that act, they also have their own court rules, and it is called the Queensland Civil and Administrative Tribunal Rules. So QCAT deals with residential and minor money disputes. And in that, if somebody wishes to submit evidence in the way of an affidavit, again, this document lists the rules of how that affidavit must be submitted. An example for federal legislation is now on your screen. So the Family Law Act 1975, in that the Family Law Rules 2004 govern how any affidavit must be submitted to a federal court when dealing with a family law matter. So you can see while we have the Oaths Act 1867, we have these other acts and court rules that govern how an affidavit must be structured or formatted, but remembering it is up to the deponent to seek that independent advice to ensure that the affidavit is formatted correctly. Now, why would someone make an affidavit? So most court and tribunals allow for evidence for a matter to be submitted in the form of an affidavit. So if an applicant or respondent is relying on evidence from a third party, they too can submit a separate affidavit to support that matter. So an example on your screen could be the person on the left there is experiencing a money dispute, which they have not been able to resolve privately. So they've decided to apply to have it resolved in QCAT, the Magistrates Court, District or Supreme Courts, and that depends on the amount of money owed. But the first step for the person is to lodge an application for that claim and serve the other party. And in that application, additional evidence can be provided to the court or tribunal by way of an affidavit to support their claim. So with the application will be the affidavit, and then the court or tribunal will make the decision. So our person here on the screen, before they make their affidavit or submit it to the court, they will have to present it to a Justice of the Peace or a Commissioner for Declarations for witnessing, and they must swear or affirm the contents of the document. And the reason why the deponent must swear or affirm the affidavit, it's because it would be the same as providing verbal testimony in a court of law. And if the affidavit is sworn, this means that the deponent is promising to tell the truth as they hold a Bible or another religious text at the time of having the affidavit witness. Now, in today's multicultural society, the law does recognise a person's right to have beliefs other than Christianity, and there are various oaths for people with other religious beliefs. And the different types of oaths are covered in detail in Chapter 4.6 of your handbook, Administering Oaths and Affirmations. While it is recommended to have a Bible in your signing kit, if you are presented with an affidavit and the deponent does have another religious belief, they will actually have to provide their own religious text to you in order to swear the affidavit. Now, if the deponent does not have any religious beliefs, they can take an affirmation. This means that they are affirming or stating that the affidavit is made on solemn truth. Okay, and on your screen now, you'll see the wording of both the sworn affidavit and the wording for the solemn affirmation. Regardless if the deponent swears or affirms, there is no lesser obligation to tell the truth when making an affidavit, and the penalties remain the same. That is, if they're making a false affidavit or false contents in that affidavit, regardless if they swear or affirm, the penalty of imprisonment or monetary fines doesn't differ. Now, before we take a look at an actual affidavit, you will see here on your screen the difference between the sworn and the affirmed. So at the beginning of an affidavit will be the deponent's name, and they will make oath and say. And at the end of the affidavit, which could be multiple pages long, it will be signed and sworn by the deponent. Whereas with an affidavit that has been affirmed, the deponent will solemnly, sincerely, and truly affirm and declare that. And then at the end of the document, it will also be solemnly, sincerely, and truly affirmed and declared. It's very important to check that at the beginning of the affidavit and at the end of the affidavit, that the deponent's choice to swear or affirm is consistent and reflects if it's an affirmation or a sworn oath. Okay, we're going to take a look at some sample affidavits on your screen. I'm just going to bring them up in a larger format for you. These affidavits have been created specifically for today's webinar, and the affidavit on the left is a sworn affidavit. So make oath and say, and at the end it's signed and sworn. And the affidavit on the right hand side is an affirmed affidavit. So do solemnly, sincerely, and truly affirm and declare, and you'll see at the end solemnly, sincerely, and truly affirmed and declared. And that is what I was just talking about. The most common mistake on an affidavit that is witnessed is the inconsistency of the beginning of the affidavit and the ending where the jurat is, and this is the jurat. It is very important to check that if your deponent is swearing, the choice is consistent at the end of the document. I'm going to give you a few minutes just to read these contents of the affidavits, because they do actually have some common misconceptions and truths for making and taking an affidavit, as well as some important steps when issuing your oath or affirmation. So I'll give you a few minutes to read that. Lovely. So when you are presented with an affidavit for witnessing, not only should you ID the deponent and making sure that the person in front of you is indeed the deponent. So in this circumstance or example, it's William Shakespeare. You want to make sure that they understand that making a false statement under oath or affirmation is a criminal offence and liable to punishment. You also want to make sure that they understand the nature and the contents of the document, and As illustrated in this example, you can either administer the oath or affirmation at the beginning or at the end. Okay. The advantage of issuing an oath or affirmation at the beginning of a witnessing transaction is that anything that is disclosed verbally during the transaction forms part of that testimony or that solemn oath or affirmation. Now, when you administer the oath, again, you can instruct the deponent to answer your question. So, do you solemnly, sincerely, and truly affirm and declare that the contents of this affidavit are true and correct? And you can instruct them to answer, I do. Or if you wish, you can also ask them to read out the statement for an affirmation or an oath. However you wish to do it, that is totally up to you. We just recommend that you have your procedure and you keep to that procedure when you are witnessing. And you can also look in your handbook under Chapter 4.1 about administering oaths and affirmations as well. Now, what happens if you are presented with an affidavit and there is no Bible handy? Well, the good news is we have a technical bulletin to cover that now. It was issued in December 2018, and it serves to inform witnessing officers on the use of a mobile device such as a Kindle, iPad, or mobile phone that can contain electronic religious texts, and you can use that for the purposes of taking an oath. Okay, so that is, of course, if you don't have the Bible handy. So if you do not have a Bible or the other religious texts to use to swear the oath, you do have this option now. Bear in mind, though, it is not your responsibility to provide the mobile device. It's a suggestion you can provide to the deponent to see if they do have a religious oath downloaded onto their mobile device. This technical bulletin can be found on our publications portal. If you visit there at www.qld.gov.au/JPS, you will be able to find that publication portal. Now we're going to take a look at some of the types of affidavits that you may be asked to witness. And when I mean types, I'm talking about the format, the look, the feel of an affidavit, and why this affidavit is being witnessed or submitted to a receiving agency. In this instance, all the samples I'll be showing you will be going to a court of law. So you can see that's why the affidavit is used, because it is in place of verbal testimony. This example on your screen is an affidavit of justification, and it's authorised under the Bail Act 1980, and it allows for an alleged offender, or in this case a defendant, Matilda Mary Devine, to apply to a court of law to be released on bail. Now, in order for that to happen, a person other than the defendant, so other than Matilda, must guarantee that the defendant will abide by the bail undertaking. That means that they must guarantee that Matilda will show up at the court hearing, otherwise she can be remanded in custody. So the person in this instance is Frederick James Devine, and that person is known as a surety. And Frederick is actually going to agree to provide a sum of money or real estate property to the courts to ensure that Matilda will actually return. Okay, in order to do this, though, not only does this affidavit need to be sworn and affirmed, you will need to cite extra documents and not just the affidavit of justification. In order for the surety to be submitted to the court, you will need to obtain a copy of the bail undertaking from the relevant court. So that will show you the charges against the alleged offender and any bail conditions that they may have been imposed by the court. And then apart from the bail undertaking document, you will also need to cite evidence of what the surety is agreeing to provide to the court. For example, in this instance, Frederick is advising the court that he owns the real estate at Etheridge Station and also a penthouse apartment, and it looks like a property at 154 Melbourne Street. You would need to cite evidence that Frederick James Devine does own that real estate, okay, because a person cannot provide any surety unless they own that property or that money. Again, Frederick has said he has a term deposit of $150,000 and you would want to see evidence of that term deposit. Now, once you have those documents, you would go through the form making sure all relevant questions have been completed, and then you would be asking Frederick James Devine or the surety, are they still happy to go ahead with the affidavit of justification, ensuring that they do understand the charges, any bail conditions, and any other requirements that have been applied by the court. Now, if they don't, then obviously you wouldn't be going ahead with witnessing the affidavit. Then you would cite Frederick's ID, you would put Frederick on oath or affirmation, and in this case, he has signed, he has made it the oath. He has made this affidavit on oath and signed it and signed and sworn. So you can see that is consistent, and that's very important to check. You would then sign the affidavit yourself, inserting your seal of office and registration number, as well as completing the jurat section, taking and sworn before me at Cairns in the state of Queensland this 9th day of April 2019. Now, the Bail Act 1980, the section that is applicable to this affidavit of justification is section 21. And there are some special conditions that the surety must adhere to. So not everyone can be a surety. They have to be over the age of 18. They can't be convicted of an indictable offence. They also can't be an involuntary patient under the Mental Health Act 2016, or a forensic disability client, a person for whom a guardian or administrator has been appointed. They can't be insolvent or under administration, and they have not been or not likely to be charged with an offence. So those points starting from 11 right through to 16 come straight from that section of the Act. Now, another document that you may be asked to witness in relation to an affidavit is this Queensland Police document, Objection to Bail Affidavit. Now, this is in reverse. Previously, we just saw Frederick, who was a surety, placing an affidavit of justification to allow Matilda release on bail. This, however, is in reverse. The Queensland Police here have actually opposed bail for Matilda in this example. And how this would have happened was Matilda would have been arrested and charged with a serious offence, and then would have been formally refused bail at the watch house. Okay, so that means Matilda will be held in custody at the watch house until the court hearing, and then the officer investigating this matter, in this case Senior Constable Armfield, has deemed that Matilda is a risk to the Queensland community and should not be released on bail. So this matter will be heard before a court, and the magistrate or judge will determine whether or not to agree to holding Matilda in custody or releasing her on bail. The officer will complete this affidavit and will also provide this document, which is the Objection to Bail Affidavit Annexure. So you must have both of these documents. You'll see here that this basically states that she is the investigating officer and all facts, allegations and other matters referred to in the annexure marked with the letter A. So the annexure is the story of how Matilda was arrested, why she shouldn't be released on bail. So you would also swear or affirm this document, and again you can put the officer on oath or affirmation at the very beginning, and then you would also do the same for the annexure. So this is a Queensland Police document. It is not available from the court website, so it's an internal document, and this will then be presented to a court of law by the police prosecutor. So remembering again, the affidavit is evidence, is used for evidence in a court of law. So Lillian Armfield actually will not be required to attend the hearing. The police prosecutor will submit this objection to bail on behalf of the officer. Again, we've created this document for today's webinar and we've just used some block text. Doesn't really make any sense, but it will tell the story. It will have the alleged offender's previous criminal history, their current offences that they've been charged with, and it can be multiple offences. It will also have any history of any previous grants of bail or any other evidence that shows the nature and the seriousness of the offence and why Matilda is deemed to be a threat to the Queensland community. So it is a solemn document, and again you would have to swear, the deponent, the senior constable, would swear or affirm these documents in front of you, and after swearing or affirming, don't forget to issue the warning, and then you would witness the deponent's signature here, in this case the police officer. These documents only require your signature, not your full name, so you just need to sign the document and insert your seal of office and registration number. One thing I didn't mention, this document will actually detail where the offence is situated in either the Criminal Code or in this case the Weapons Act 1990. Okay, and it can be more than one. The next affidavit that you may be asked to witness is for QCAT, so the Queensland Civil Administration Tribunal, and as mentioned, it deals with minor money disputes or residential tenancy disputes. In this case, Olive Green is the applicant, and because Olive here is making the affidavit, she is also the deponent. Okay, so remembering a third party can actually make an affidavit to support somebody's matter before a court of law. So always check that the deponent is the person in front of you, because the deponent may not be the applicant. But in this case, Olive is placing an affidavit to QCAT, and she's made a number of statements. And because it is a multiple page, both Olive and the JP have signed each page, and if it hasn't been numbered, you should instruct the deponent to number each page. Now, one thing I would like to point out, you'll see here that Olive has referred to some annexures. So annexed here too, and marked A, and then you've got marked B and C and D and E. So before you would witness this affidavit, you would actually have to ensure that those attachments are with the document. If those annexures are not with the affidavit, you would actually have to decline to witness, because these annexures also have to be signed, sworn or affirmed, and we will go through that step shortly. The final example that you might ask, and a final affidavit you might be asked to witness, is an affidavit going to the Magistrates Court for a family and domestic and family violence matter. And you can see here that this is a perfect example of what I was just talking about. The aggrieved in this case is Betty Smith and the respondent is Bobby John Boggs. Now, however, James Fraser is making the affidavit. So you want to make sure that James Fraser is in front of you and not Betty Smith. Okay, so James is making this statement, and then again it's a multiple page document, and you would ask James to sign, and we can see our JP has signed this page as well, and if it's not been numbered, you would ask them to number it. And this one here, James is solemnly and sincerely affirming and declare, and you can see at the end of it, the choice of affirmation is consistent with the document. So again, you would sign, insert your seal of office, okay, once you have placed James on oath, in this case affirmation, and issuing that warning. Yes, and if you are reading these affidavits, or these 2 pages of the affidavit, there are some not colourful language, but language that if you do come across, then unfortunately that is the truth in the story. So I hope no one's offended by that today. Let's move on to attachments. So we just saw in one of the examples that the one that Olive was submitting to QCAT, she had a number of annexures included in her affidavit. Again, the rules of the court or the tribunal will govern how the attachments are to be treated, but essentially attachments are referred to as an exhibit or annexures. And we're going to talk about what is the difference between those two. Okay, so under the Uniform Civil Procedure Rules, a document or attachment mentioned in an affidavit is referred to as an exhibit. And an exhibit to an affidavit must have a letter or other identifying mark on it. Okay, and it also has to have a certificate in the approved form. Again, this is a perfect example of the rules, the Uniform Civil Procedure Rules. It is up to the deponent to be aware of these rules. But on your screen, this top annexure or the exhibit wording is relevant for the UCPR. So this page and pages, let's say 1 to 5, are the particulars marked A, referred to in the affidavit of, and you'd put the deponent's name here, and then either marking if it was sworn or affirmed before me at the location and then the date. And the difference between an exhibit is that the deponent has to sign, whereas if it's an annexure, only the JP has to sign this annexure stamp. And to the left here, this is a certificate of exhibit which must accompany all exhibits to an affidavit in the Uniform Civil Procedure Rules. But again, it's the role of the deponent to seek that independent advice to ensure that the affidavit and any attachments are structured correctly. Now I'm going to actually go through an affidavit that's been submitted for a claim under the Uniform Civil Procedure Rules, just to show you how an affidavit and any attachments or exhibits may look. So let's imagine that you've been provided this affidavit, and Olive Green is the plaintiff, and Olive Green is also the deponent in this matter. You can see that she's decided to make this affidavit on oath, and she's made a number of statements. Okay, so we would first cite Olive's ID, and reading through the affidavit, you can see that the deponent is referring to Exhibit A, Exhibit B, Exhibit C, and Exhibit D. So you do want to make sure that those 4 attachments have accompanied the affidavit. As mentioned, if they haven't, unfortunately you cannot go ahead and witness the document, because exhibits have to be witnessed with the affidavit at the time of the witnessing. So let's take a look at the first exhibit, because that's what I do when I'm witnessing an affidavit and I notice there are exhibits. I look for each exhibit before I go ahead and witness. So Exhibit A, and in this case you can see here that Exhibit A, it's been clearly marked on this exhibit. Okay, so happy with that one. Then I'd be looking for Exhibit B, and again, it's been clearly marked at the top. And if you're not sure, it's okay to refer back to the affidavit. So sentence 2 here says, on the 31st of January, judgment was entered for the plaintiff against the defendant in Townsville Magistrates Court in the amount of $24,079.20, including so many costs. And annexed hereto and marked Exhibit A is a copy of the judgment. Okay, so you can check that yes, it's the judgment, but it isn't your responsibility if they have made an error. You can point that out to them, but it'll be up to a court of law whether or not they'll accept that exhibit. Continuing on to Exhibit C, again, it's clearly marked, and that's referred to in the affidavit, so I'd be happy with that. And then the final exhibit, yep, Olive has that as well. And you may say, well, hang on, it hasn't been signed, but that's okay because it is still an exhibit. Okay, remembering it's up to a court of law to decide whether or not to accept that exhibit. So I'm happy that Olive has provided all those exhibits. I would then issue the warning and the oath, and then I would ask Olive to sign before inserting my own signature and seal of office, as well as completing the jurat, which is down here. And now that I've witnessed the affidavit, and remembering because it's multiple page, I would also have to sign page 1 and ask the deponent Olive to sign that as well. I now actually have to mark each exhibit with the exhibit wording. So using my stamp, my Inaction stamp, that's what we do call it, even though we are dealing with exhibits, I would then complete that this page and page 1 to 1 are the particulars marked Exhibit A, referred to in the affidavit of Olive Green, sworn, because remember Olive swore the original affidavit before me in Townsville on this 11th day of April 2009, then the deponent would have to sign. Now that would have to be accompanied on each exhibit. So we would have to do this 4 times for Exhibit A, B, C, D. If they're multiple pages, you need to ensure that the exhibit, if it is multiple page, you have to reflect that information here. You do not have to sign the actual exhibits themselves. You only have to sign this certificate of exhibit. However, if your client has sought independent advice, then more than likely they're going to have this type of document, and it's formatted straight from the UCPR rules. Okay, and it's the certificate of exhibit which has bound all of the exhibits. So you can see here, bound and marked A to D are the exhibits to the affidavit of Olive Green, sworn, and then again we would just ask Olive to sign here and we would sign here. So that's allowable under the rules. So this may be accompanied with the affidavit and the exhibits. That's fine, because this would then go on top of all 4 exhibits and then be attached to the affidavit. And that's something for the deponent to do. We do not staple or attach the documents ourselves. So just to recap, this affidavit is one of the commonly used affidavits under the UCPR. I've checked for the exhibits and I'm happy that all 4 exhibits are there. And I'm also happy that Olive, or the deponent, has provided me with a certificate of exhibit. Okay, now remembering if they haven't provided a certificate of exhibit, then we can use this wording on each of the exhibits. You can use a blank page and put that blank page on top of each exhibit, or if the exhibits are single-sided, you can actually place this wording on the reverse side on that blank page.
Moving on, I'd like to quickly show you what a sample affidavit for a family law court matter may look like. For those who may be familiar with the lengthy application for divorce, this transaction can now be made electronically online, called e-filing. Parties wishing to apply for divorce must first visit the Commonwealth Courts portal and lodge an application for divorce online. And once that application is fully completed, the party or parties will be provided with an affidavit for e-filing, which is currently being displayed on your screen. This affidavit is then downloaded and is the only document that is required to be witnessed and not the multiple-page application for divorce. Either or both parties can file for divorce, and in this example, the wife, Judy Ann Law, has commenced the proceedings. Judy would have completed and provided all the required information for the divorce application online, including her husband's details and information surrounding the marriage, before printing out this 2-page affidavit. Remembering you're not required to see that full divorce application for this type of electronic scenario. So please don't ask your client to go away, print out the application and return with it, or decline to witness it purely based on the fact you haven't seen the application, because it is just an affidavit. And you can see here at the top, it is an affidavit for e-filing, and the party, Judy, can either swear or affirm. So we're going to treat it like an affidavit. In this case, Judy has decided to affirm before Robert Gordon Brown, who is our Commissioner for Declarations. And Robert would have placed Judy on affirmation after identifying her and making sure she understood the nature and the contents of the document. Robert also would have issued that warning about making any false or providing false information is an offence, before completing this section here, which is also known as the DRAT. Now, I'm moving on to the final section of our webinar, and it's purely going to be about record keeping. It is very important that you do keep detailed records, and on your screen is our logbook. And you can order this online through our JP shop, or you can even download it from our publications page.
Now, the reason I like this logbook is because not only does it have the summary of your general witnessing steps, it has your oath and affirmation wording. Okay, so you can actually ask your deponent to either swear or affirm using this information on the cover of your logbook. And remembering, when you are keeping records, please do not record personal identifying information. Okay, so no driver's license numbers, no passport numbers. A perfect example of what to record is the date, the type of document witnessed, the name of the deponent, remembering that the deponent may be different to the applicant or the aggrieved, the type of identification cited, and if you are concerned that if you're going to be asked, was it a current ID, I always put the expiry date, location of signing, and then any comments. So something unfamiliar happened, or something that raises an alarm, or you wanted just to make a little note about the witnessing transaction, perfect space to put that here. Well, that's it for today. I hope you were able to take something away from this webinar. And don't forget, more information can be found in your handbook in Chapter 4.7, Witnessing Affidavits, which also includes some really great samples as well of blank affidavits. Thank you once again for joining me, and we hope to see you again next time. Thank you.